constitution, the highest office of the Shivsena political party is Shivsena Pramukh, but the said constitution distinguishes highest office and the highest authority and provides that Rashtriya Karyakarni is the highest authority whose decision shall be final. Shivsena SS constitution provides that the members of the Rashtriya Karyakarni shall be called as Shivsena leaders and provides for a total number of 19 members, out of which 14 are to be elected by the Pratinidhi Sabha and the rest of the 5 members are to be appointed by Shivsena Pramukh. However, the 2018 leader structure envisages only 13 members in the Rashtriya Karyakarni, out of which 19 are to be elected and the remaining 4 are to be appointed. SS Constitution provides for a total number of 21 deputy leaders, out of which 17 are to be elected by the Pratinidhi Sabha and the rest of the 4 members are to be appointed by Shivsena Pramukh. However, the 2018 leaders structure envisages 33 deputy leaders, out of which 21 are to be elected and the remaining 12 are to be appointed. The 2018 leadership structure provides for 3 categories of office bearers, vis-a-vis secretary, samanvayak and sanghatak. However, the constitution of Shivsena provides for 3 categories of office bearers, vis-a-vis president, shidne, general secretary, koshadhyaksha, treasurer. From the observation recorded in the preceding paragraphs, it is evident that the 2018 leadership structure is not at all in conformity with the constitution of Shivsena. In view of this finding alone, it could very well be concluded that the 2018 leadership structure, which is not in conformity with the constitution of Shivsena, cannot be taken as the yardstick to determine which faction was the real political party at the relevant point of time. In view of the same, I have come to the conclusion that the 2018 leadership structure read with the SS Constitution does not provide a reliable outcome and or answer the question which faction is the real political party, and hence cannot be relied upon to determine the said preliminary issue. Nevertheless, I am inclined to look at the second question regarding paragraph 115 herein above, where will of the Paksha Pramukh and or majority leaders in the 2018 leadership structure could be said to be synonymous with the will of the political party, so as to not leave any stone unturned in arriving at a decision. The determination of this question arises out of the alternate submissions made by the UBT faction that the 2018 leadership structure has to be taken ex facie, and the determination of which faction was the real political party has to be solely based on the said leadership structure without a comparison of the said structure with the leadership structure provided for in the constitution of the Shivsena. The said proposition would run counter to the principles laid down by the Honorable Apex Court in Subhash Desai Supra, where it was specifically provided that the leadership structure which has to be taken into consideration while determining the real political party has to be identifiable by the relevant constitution. Thus, although in the light of my finding on the preceding question, the aspect need not be looked into, however, I intend to look into the said aspect any which way, considering the gravity and importance of the dispute. Hence, following are my observations, findings and conclusions on the said aspect. UBT faction has submitted that the decision of the Paksha Pramukh is synonymous with the will of the political party, and thus if there is a rift in the leadership structure, the decision of the Paksha Pramukh constitutes the will of the political party. This proposition is devoid of merit, as I do not find any substance to allow the same. The reason for the same are recorded herein below. The proposition perhaps would have been a valid point if the party president was the sole repository of the decision making with respect of the policy and administration of the party. For analyzing the said submissions, a perusal of the SS Constitution was made. The SS Constitution provided that Rashtriya Karyakarni shall be the highest authority of the party, and its decision in all matters concerning the party policy and party administration shall be final. It is also to be noted that the Paksha Pramukh is only a presiding member of the said highest authority in the party, and in no way is the sole repository of decision making in the party. Thus, in view of the same, the submission that the decision and or the will of the Paksha Pramukh is synonymous with the will of the political party cannot be accepted. It would be appropriate to note that the SS Constitution does not even have a post called Paksha Pramukh. However, it was argued by the UBT faction that the nomenclature difference in the 2018 leadership structure and the SS Constitution is not a relevant factor for the purpose of deciding the preliminary issue. Even though I have held in paragraph 117 that 2000 leadership structure is not at all in conformity with SS Constitution, I shall consider this submission. The Constitution of Shivsena provides for Shivsena Pramukh. The submission of the petitioner that Shivsena Pramukh mentioned in the SS Constitution is the same post of Shivsena Paksha Pramukh termed in the 2018 leadership structure. By relying on the powers of Shivsena Pramukh, it was argued by the UBT faction that he is the authority under the party constitution vested with the powers to remove any member of the party. Thus, it was further argued that an authority who is vested with such power of removal reflects the will of political party with respect to removal of members from and for anti-party activities. However, a complete reading of the said provision in the party constitution reveals that the said submission is factually wrong. The said provision in relation to the powers of Shivsena Pramukh clearly provides that such power is not absolute, and it has to be exercised in consultation with the Rashtriya Karyakarni. Further, it has to be noted that such a power is only available to the Shivsena Pramukh for the purpose of removal of members mentioned in Article 8, Schedule B of the said Constitution. The said schedule does not deal with leaders of the party. Leaders of the party is given under Schedule A of the said article. Thus, Shivsena Pramukh does not have any power to remove any leader of the party. Thus, the submission of the petitioner that Shri Uddhav Thackeray, Vide, letter dated 30/6/2022, had removed Shri Eknath Shinde from the post of Shivsena leader cannot be accepted, as such power are not vested with the party president. Hence, on this ground also, the submission that the decision and or the will of the Paksha Pramukh is synonymous with the will of the political party cannot be accepted. If this proposition is accepted, then in a situation where the party president, who is also a legislator, itself defects, then he could simply escape the wrath of the 10th schedule by pleading that his decision is the will of the party. Further, if this proposition is to be accepted, it would mean that no member can ever voice concern against the party president, and the party president might possibly be able to seek disqualification against any member who questions his credibility. This would run contrary to the concept of intra-party dissent. In view of the clear and unequivocal finding of the Honorable Supreme Court at paragraph 183 to 190 of Subhash Desai, I will be falling foul of the judgment of the Honorable Supreme Court in Kyoto Holohan, wherein the constitutional validity of the 10th schedule was itself upheld on the grounds that it is not an anti-dissent law, if this proposition is accepted. I shall now proceed to consider whether the will of the majority leaders in the 2018 leadership structure is synonymous with the will of the political party. An alternate submission was made that even if the Paksha Pramukh is not accepted as the repository of the will of the political party, the decision of the leadership structure has to be construed as synonymous with the will of the political party. This proposition is also devoid of merit, and I do not find any substance in it for following reasons. In a circumstance where there is no dispute amongst the leaders identifiable by the constitution of a political party, the proposition would have held water. However, the factual matrix of the present matter is different. This is a matter where there is a dispute within the leadership structure itself. It is to be noted that in the present matter, rival factions have emerged in the legislature party, political party, and thus inevitably amongst leaders of the party as well. Thus, it would not be wise to apply this proposition in the present matter. The existence of split stroke rift in the leadership structure is admitted by the petitioner and or the UBT faction, as can be inferred from the petitioner's affidavit in lieu of examination in chief of PW1, petitioner himself, that the leader of the UBT faction did not have the support of all the members of the 2018 leadership structure when rival factions emerged. Thus, the submission that the decision of the leadership structure has to be construed as synonymous with the will of the political party could have perhaps be applied in a situation where there is a dispute between some members of the party and the elected leadership. In such a case, the leadership of the party could have possibly taken the stand that their decision would have to be taken as the decision and will of the political party until they are so removed from the leadership structure by a mechanism recognized by the constitution of the said political party. However, as I have noted earlier, in the present matter, rival claims have emerged wherein the leadership structure about the leadership within the leadership structure about the leadership itself. In such a situation, one leader's contention that his will is the will of the political party would be contradiction in terms. Thus, when there is a vertical rift in the party and two factions within the said leadership structure emerge as a result of the said rift, leaders of either faction, both Shri Uddhav Thackeray and Shri Eknath Shinde, could equally claim to represent the will of the political party. In that case, it would not be appropriate to take their decision as the decision that carries the will and wish of the political party when the question of which faction is the political party is being considered. There possibly lies one more aspect which could be considered. Does the stand-stroke decision of the majority members of the leaders within the leadership structure, identifiable and appointed according to the constitution of the political party, could be construed as the will and desire of the political party in the event there is a dispute within the leadership structure? For the purpose of answering this question, one must look into the constitution of the political party. In an event where the party constitution provides for a mechanism to resolve a conflict of decision within the leadership structure, then in that case it would have been a guiding factor. However, if the party constitution does not provide for such a mechanism, then in that case it would not be appropriate to say that the decision of the majority leaders would have to be accepted as the one which conveys the will of the political party. This aspect need not be further considered in view of the fact that in any case UBT faction has not placed any material on record or even suggest that any meeting of the Rashtriya Karyakarni was called for where any decision in relation to the real political party was resolved so as to identify the leaders and or the whip who carried the will of the political party. Thus, in the absence of any such material, including any majority decision of the Rashtriya Karyakarni in relation to the real political party, identifying the leader and or the whip who carried the will of the political party would be an impossible task. Any conclusion reached would be without basis in law and evidence of fact. The submission that the UBT faction shall be taken as a real political party is entirely based on the conjuncture that if there will be a decision taken in relation to the political party by Rashtriya Karyakarni, then UBT faction would have had the majority. At this juncture, the petitioner's claim about a meeting purportedly held on 25th June 2022 has to be dealt with. It is the petitioner's case that Rashtriya Karyakarni meeting was held on 25th June 2022 and certain resolutions were passed. In support of this case, petitioner has produced certain resolutions of 25th June 2022. Those documents are disputed by respondents. Mr. Jetmalani, learned counsel for respondent, objected to the said documents being considered on the ground that they were forged and fabricated, and demonstrated this before me by showing two separate documents, one annexed by the petitioner Shri Sunil Prabhu to his affidavit in lieu of examination of in chief, and the other set of the same documents which are annexed to the Supreme Court Convenience Compilation Volume 2. In the first set of documents annexed to the affidavit in lieu of examination in chief, termed as minutes of the meeting of Rashtriya Karyakarni, and purportedly 7 resolutions passed in the said meeting. In none of the resolutions there is any signature of any person whose name are shown on the said document. Only on page 105 of Sri Sunil Prabhu's affidavit in lieu of examination in chief, there is a sole signature of Sri Vinayak Raut, who is shown as Shivsena secretary. The perusal of the said document shows that the meeting was termed as Rashtriya Karyakarni. In the second set of documents, which are annexed to the Supreme Court Convenience Compilation Volume 2, the resolutions are shown on different pages, and they are not part of any minutes which was annexed to the affidavit in lieu of examination in chief of Sri Sunil Prabhu. These resolutions are shown on the letterhead of Shivsena, Rashtriya Karyakarni Baitak into bracket Pratinidhi Sabha. Petitioner relied on these documents to show that 7 resolutions have been passed, but in none of these documents there is even a single signature, save and except for signature of 2 persons. The name mentioned as proposer and seconder are not even members of Rashtriya Karyakarni, like Shri Rahul Shivale, who is not a member of Rashtriya Karyakarni, who has stepped into the witnesses and led evidence that there was no such meeting. The same is the case with Shri Vinayak Raut and Shri Arvind Sawant. They are also not members of the said Rashtriya Karyakarni. The petitioner had claimed that the said meeting was held on 25/6/2022 at Sena Bhavan, whereas Shri Uddhav Thackeray claimed that the said meeting was held through video conference. This has been stated by Uddhav Thackeray in his submission before the Election Commission filed on 9/1/2023. This itself casts a doubt on the authenticity of the documents and holding of any such meeting of either Rashtriya Karyakarni or Pratinidhi Sabha. The petitioner himself is not sure whether it was Rashtriya Karyakarni or Pratinidhi Sabha. Thus, in view of the above said documents, the said documents cannot be permitted to be relied on. Petitioner suggests that a look into how the Shivsena settled conflict or decisions within the leadership structure in the past might shed some light into this. However, in the present matter, no such material are placed before me to even suggest such instances which happened in the past, where the majority decision within the leadership structure is taken as the will of the political party. It is to be also noted that the petitioner has neither placed nor provided any material to show that historically the decision of the majority within the leadership structure is taken to be the final decision of the political party whenever there was a conflict of decision within the leadership structure. Thus, for this reason also, it would not be appropriate and correct to accept the proposition that the decision of the majority leaders within the leadership structure would have to be accepted as one which conveys the will of the political party. As a passing note, I must also add that the majority rule possibly could have been applied in a normal situation where there is dissent in respect to some policy and or administrative decision of the party. However, such a simple rule stroke test shall not be applied to determine an essential question in existential question in relation to the political party, such as in the present matter, where which faction is the real political party is required to be determined. Thus, in view of the decisions recorded herein above, I am not inclined to accept submissions of the UBT faction that will of the majority leaders in the 2018 leadership structure is synonymous with the will of the political party. Thus, from paragraph 112 to 128, I have dealt with whether the relevant leadership structure read with the Shivsena constitution, SS constitution, provides answer to the question which faction is the real political party. In view of the same, I record my conclusion and finding thereon as under. (2018) leadership structure is not at all in conformity with the constitution of Shivsena and thus does not provide a reliable outcome and or answer to the question which faction is the real political party and hence cannot be relied upon to determine the preliminary issue. Decision of the Paksha Pramukh is not synonymous with the will of the political party and thus if there is a rift in the leadership structure, the decision of the Paksha Pramukh cannot be taken as the will of the political party. When there is a vertical rift in the horizontal leadership hierarchy of the political party and both the factions within the said leadership structure emerged as a result claim to represent the will of the political party, it would not be appropriate to apply the test of which of the said faction decision carries the will and wish of the political party. In the case of Shivsena political party, will of the majority leaders in the 2018 leadership structure cannot be said to be synonymous with the will of the political party. In view of the findings recorded in the preceding paragraph, I hold that the 2018 leadership structure read with the SS Constitution does not provide any reliable answer to the question which faction is the real political party and consequently the 2018 leadership structure cannot be yardstick to determine which faction is the real political party. With regards to the legislative majority, I am not going to spend much time because that question is rather clear. In view of the above observations and findings, I hold as follows. Which faction is the real political party is discernible from legislative majority which existed when the rival factions emerged. Legislative majority which existed when the rival factions emerged can be discerned and or inferred from 1. The Shinde faction resolution dated 21st June 2022 and 23rd June 2022 available on record of the Legislature Secretariat and the admitted position which can be inferred from the initiation of petitions against 38 legislators of Shinde faction by the UBT faction. Shinde faction had an overwhelming majority of 37 out of 55 MLAs with the when the rival faction emerged. From my analysis, observations, conclusions and findings recorded in paragraph 82 to 144 herein above, I hold that Shinde faction was the real Shivsena political party when rival factions emerged on 21st June 2022. In view of my findings that the Shinde faction was the real political party when the rival faction emerged and that Shri Sunil Prabhu ceased to be the duly authorized whip from 21st June 2022, I further conclude that Shri Bharat Gogaole was validly appointed as the whip, as that was the reflection of the will of the Shivsena political party as on 21st June 2023. Following are the final conclusions, which is again a summary. Have the respondents incurred disqualification in terms of paragraph 21A of the 10th schedule of the Constitution on account of their acts, omissions and conduct? I will also read the final conclusion. Following are the final conclusions from the analysis, observations, conclusions, findings and rulings recorded from paragraph 82 to paragraph 158 herein above. I conclude as follows. Shinde faction was the real Shivsena political party when the rival factions emerged on 21st June 2022. Shri Sunil Prabhu ceased to be the duly authorized whip from 21st June 2022. Shri Bharat Gogaole was validly appointed as the whip of Shivsena political party on 21st June 2023. Shri Eknath Shinde was validly appointed as the leader of the Shivsena political party on 21st June 2023. Have the respondents incurred disqualification in terms of paragraph 21A of the 10th schedule of the Constitution on account of their acts, omissions and conduct? Petitioner has contended that the respondents are liable to be disqualified on various grounds. Both the petitioners and respondents' submission are recorded in section 2 herein above. The various grounds on which the petitioner based the plea for disqualification is dealt with, where the alleged conduct of the respondent is purportedly becoming totally incommunicado, attracts disqualification under paragraph 2(1)A of the 10th schedule. Whether the alleged conduct of the respondents in purportedly becoming totally incommunicado attracts disqualification under paragraph 2 subclause 1 subclause A of the 10th schedule. The first ground on which the petitioner sought disqualification of the respondents is that the respondents became incommunicado. The submission cannot be accepted and the respondents cannot be held to be disqualified on this ground for the following reasons. The ground is a mere allegation, and apart from mere assertion that the respondents have gone incommunicado, the petitioner has not put forth any evidence or material to substantiate it. For instance, the petitioner has not provided any material about who was sought to be contacted and by whom, when such an attempt was made, etc. A mere unsubstantiated statement that the legislators have gone incommunicado cannot even be a ground to attract disqualification under paragraph 21A of the 10th schedule. When rival factions emerge in a political party, especially within the leadership, it is possible for both the factions to allege that the other faction has gone incommunicado. In such a circumstance, especially in the light of the law laid down by the apex court in Subhash Desai Supra, it would not be correct to hold any faction to have incurred disqualification for going incommunicado without first determining which of the faction is the real political party, reflecting the will of the political party. Also, having held that the Shinde faction was the real political party when the rival factions emerged, the submission of the petitioner that the respondents have gone incommunicado ceases to hold any meaning for the purpose of disqualification. On the 20th of June 2022, elections for the Legislative Council were held. In his cross-examination, Shri Sunil Prabhu, PW1, stated that all the MLAs were present for the same. In the face of this evidence, it would not be possible to accept that the legislators had gone incommunicado. Respondents have placed that they have been in touch with the UBT faction. They substantiated it by stating that Shri Milind Narvekar and Shri Ravindra Phatak, MLC, of the UBT faction, had gone to Surat and met Shri Eknath Shinde and other respondents on 21st June 2022 on the instructions of Shri Uddhav Thackeray. This fact was not denied by the petitioner Shri Sunil Prabhu when a suggestion was put to him in the cross-examination. In fact, the petitioner admitted that Shri Milind Narvekar and Shri Ravindra Phatak, MLC, of the UBT faction had gone to Surat and met Shri Eknath Shinde and other respondents. Also, three of the witnesses for respondents have testified that Shri Milind Narvekar and Shri Ravindra Phatak, MLC, of the UBT faction had gone to Surat and met Shri Eknath Shinde and other respondents. On 21st June 2022, on the instructions of Shri Uddhav Thackeray, the testimony stood the test of cross-examination and the petitioner could not establish otherwise. Thus, on this count alone, or this count also, it would not be possible to accept the legislators were incommunicado, Whether the deliberate absence of the respondent in the SSLP meetings purported to be held on 21st June 2022 attracts disqualification under paragraph 21A of the 10th schedule. The second ground on which the disqualification is sought is that the respondent deliberately remained absent in the SSLP meeting held on 21st June 2022. Petitioners relied on the attendance sheet register of the meeting dated 21st June 2022. After having considered the submission advanced on this ground, I hold that respondents cannot be held to be disqualified on this ground. In view of my conclusion that 1. The Shinde faction was the real political party when factions emerged, and 2. Shri Sunil Prabhu ceased to reflect the will of the political party from the moment the faction emerged. Thus, it would not be correct to say that Shri Sunil Prabhu had any authority to call any meeting of the SSLP. Hence, on this ground alone, petitioner's case that the respondents were liable to be disqualified for non-attendance of the meeting dated 21st June 2022 is liable to be rejected. Irrespective of the conclusion that may be reached about which faction was the real political party, respondents could not be held to be disqualified on the ground that they deliberately remained absent in the SSLP meeting held on 21st June 2022. This is because of the following reasons. Petitioner relied upon the attendance sheet of the 21st of June 2022 to claim that all those MLAs who were signed the said attendance sheet were present in the meeting, while those who did not sign were not present. Based on this document, the UBT faction claimed that respondents remained deliberately absent. A comparison of the original attendance sheet produced along with the affidavit in lieu of chief examination of the petitioner Shri Sunil Prabhu, PW1, with the copy of the attendance sheet produced and verified as a true copy along with the petition, reveals that the two do not match. There are glaring discrepancies. The copy claimed to be the original of the said attendance sheet has a handwritten date of 21st June 2022, whereas the copy verified as the true copy of the original produced along with the petition does not have it. Further, Shri Sunil Prabhu stated in his cross-examination that the documents relied as the attendance sheet was in fact a register of MLAs to whom the whip of 21st June 2022 was served and received. So, facts show: 1. There are glaring discrepancies in the said attendance sheet. 2. The statements of Shri Sunil Prabhu shows the document relied upon as attendance sheet of MLA present on 21st June 2022 is in fact a register of service and receipt of the whip dated 21st June 2022 of the MLAs. Thus, the said document is unreliable and cannot be taken as proof of non-attendance of respondents in the meeting held on 21st June 2022. Hence, on this count as well, petitioner's case that the respondents are liable to be disqualified for non-attendance of the meeting dated 21st June 2022 has to be rejected. Further, all the respondents have denied the receipt of any whip for attending the meeting on 21st June 2022. Countering this, petitioner Shri Sunil Prabhu, in his affidavit in lieu of examination in chief, stated that the whip for 21st June 2022 meeting was sent via WhatsApp by Shri Marosh Harishchandra Chaugle to Shri Prabhakar Kaye, PA of Shri Eknath Shinde. In the cross-examination of Shri Sunil Prabhu stated that the whip was sent via WhatsApp to all the respondents, who according to him were not traceable. However, petitioner has not offered any statement or any material to even suggest that such WhatsApp messages were sent to other respondents. Thus, the petitioner has failed to establish that whip stroke notice was served upon the respondents in petition number 2-15, directing them to attend the meeting on 21st June 2022. As to the service of whip on Shri Eknath Shinde, the only material produced by the petitioner is an alleged screenshot of the WhatsApp message sent by one Shri Manoj Harishchandra Chaugle to one Shri Prabhakar Kaye. This does not constitute proof of any notice whip was served upon Shri Eknath Shinde, directing him to attend the meeting on 21st June 2022. Further, a perusal of the aforementioned WhatsApp message allegedly sent to the PA of Shri Eknath Shinde shows that the said message was sent at 12:31 p.m. on 21st June 2022 for a meeting which was allegedly scheduled for 12:30 p.m. Thus, it is abundantly clear that none of the respondents were ever served any notice whip for the alleged meeting dated 21st June 2022. Hence, on this ground alone, also, petitioner's case that the respondents were liable to be disqualified for non-attendance of the meeting dated 21st June 2022 must be rejected. The third ground on which the disqualification of respondent is sought is that the respondents deliberately remained absent in the SSLP meeting held on 22nd June 2022. Petitioner relied on the attendance sheet register of the meeting dated 22nd June 2022. After having considered the rival submissions, I hold that respondents cannot be held to be disqualified on this ground in view of my conclusion that 1. The Shinde faction was the real political party when rival factions emerged. 2. Shri Sunil Prabhu ceased to reflect the will of the political party from the moment rival factions emerged. Thus, it would not be correct to say that Shri Sunil Prabhu had any authority to call any meeting of the SSLP. Hence, on this ground alone, petitioner's case that the respondents were liable to be disqualified for non-attendance of the meeting dated 22nd June 2022 must be rejected. Again, even if I was to take different view about which faction was the real political party, still the respondents could not have been held disqualified on the grounds that respondent deliberately remained absent in the SSLP meeting held on 22nd June 2022 for the following reasons. I am unable to accept the petitioner's submission that non-attendance of the SSLP meeting would make the respondents liable to be disqualified under paragraph 2, 1A of the 10th schedule. I am of the view that non-attendance of party meetings, including legislature party meetings, would not attract disqualification under paragraph 2, 1A of the 10th schedule of the Constitution. Such an action cannot indicate that the members have voluntarily given up his membership of the political party. Not attending party meeting and voicing a difference of opinion outside the house are matters between the members and his party and have nothing to do with clause 2(1)(a) of the 10th schedule. Non-attendance of the meeting can at the most be termed as an act of dissent within the party. If viewed as a form of expression, it would be protected by freedom of speech and expression, which includes dissent and is not only an integral part of fundamental rights under Article 14, 19 and 21 of the Constitution, but is an aspect of the basic structure of the Constitution also. Therefore, even if the alleged non-attendance is seen as an expression of dissatisfaction, it cannot be treated as conduct attracting disqualification within the purview of paragraph 21A of the 10th schedule. Further, I find the petitioner's reliance on Shriman Bayasaheb Patil versus Karnataka Legislative Assembly 2020 2 SCC 595 is misplaced, as in that matter the disqualification was not only on the grounds of non-attendance of a party meeting, but was found to attract disqualification when considered with the surrounding circumstances, such as non-attendance of the assembly session along with non-attendance of meetings. Petitioner relied upon the attendance sheet of the 22nd June 2022 to claim that all those MLAs who had signed the said attendance sheet were present in the meeting, while those who did not sign were not present. Based on this document, UBD faction claimed that respondents remained deliberately absent. A comparison of the original attendance sheet produced along with the affidavit in lieu of chief examination of the petitioner Shri Sunil Prabhu PW1 with the copy of the attendance sheet produced and verified as a true copy along with the petition reveals that the two do not match. There are glaring discrepancies. The copy claimed to be the original of the said attendance sheet has a handwritten portion on top in which it is not which is not present in the copy annexed to the petition, verified as the true copy of the original. The original of the said attendance sheet has 17 signatures, and in the copy annexed in the petition, verified as true copy of the original, has only 15 signatures. Thus, glaring discrepancies in the said attendance sheet makes the said document unreliable and hence cannot be taken as proof of deliberate non-attendance of respondents in the meeting held on 22nd June 2022. Hence, on this count as well, petitioner's case that the respondents are liable to be disqualified for non-attendance of the meeting dated 22nd June 2022 is liable to be rejected.